juries are not dumb. People talk about 12 dummies in a box. I've never seen 12 dummies in a box. They get it. Windows open up into your personality during the trial. They figure out who the good guys are, the bad guys are. I got called to one of the vice president's office. He goes, "Congratulations, great job, appreciate what you did. But boy, we spent a lot of money to get here. What can we do?" I said, "Well, there's this new statute that was just passed. I played this very, very small role in drafting it. No one's done it yet. You'd be the first." He goes, That's what I want. Since I've been fighting fraud since the 1980s, I mean, it has been an escalation in force. It's such an arms race, and I don't know where this ends. The level of sophistication is crazy. We were able to trace the money laundering from Los Angeles to San Francisco to New York, and New York to Russia.
This is The Litigator's Edge, the podcast where smart strategy, practical innovation, and real-world experience come together to move litigation forward. Each week, we sit down with attorneys, legal tech leaders, and trusted advisors who are rethinking how great legal work gets done. You'll hear how law firms are building a competitive advantage. These conversations are grounded, insightful, and designed to help you refine how you work and how you win. Here is your host, Aniket Sawant.
Hello, and welcome to today's episode of The Litigator's Edge, the podcast where innovative attorneys reveal the strategies that have transformed their legal practice. My name is Aniket Sawant, and I'm co-founder and CEO of Threadio. My guest today is a powerhouse trial lawyer, nationally recognized for taking the fight directly to complex insurance fraud rings. He is the architect of a landmark $8.2 million verdict in the first jury trial under California's whistleblower law, a victory that created a new playbook for holding fraudsters accountable. He has helped draft anti-fraud legislation, and his trial prowess has earned him the title of California's Civil Litigator of the Year. It is my pleasure to welcome Dennis Kass to the podcast. Welcome, Dennis, and thank you for being here.
Thank you, Aniket.
Dennis, as you know, I always like to start each of these shows with asking our guests for either a fun fact about themselves or a cringe joke. Which will it be for you, and what is it?
Well, I think it has to be a fun fact because I'm just not one of those guys that remembers jokes. So let's go with a fun fact.
Sounds good.
I was actually able to have lunch with someone famous from history. Way back when, my college roommate took 4 of us to Europe. Apparently, he had a place there. We didn't know that. His family was there. And we traveled in loops and had a great time. And he said, one day, he goes, "We're going to my uncle's ranch outside of Paris. Wear a tie." We were kids. We're like, "Wear a tie?" It's 19 years old. "Wear a tie? What is that?" Okay. We get to this beautiful sprawling ranch. And after a while, all these limos start to pull up. And all these guys come out with automatic weapons. Like, what the heck is going on here? And all of a sudden, this guy gets out of one of the limos. I'm like, I know him. I had just finished a course at UCLA where we studied the 5 most charismatic leaders of all time. And number 5 was the guy getting out of the limo. It was Prince Norodom Sihanouk of Cambodia, who I didn't know my friend was part of the royal family. And so he was way down in line, but we were having lunch with Prince Sihanouk. So I got a chance to meet someone who I just studied at UCLA and talk to him over lunch and learn all about Cambodian politics. And this was not long. Well, this is while Pol Pot was actually in power in Cambodia. Quite interesting.
That's fascinating. So yeah, the setting with, this ranch in Paris, and then obviously this, this very famous and charismatic person, and then the timing that you just studied about him, I think that's what a confluence of events. That is a fun and truly entertaining and fact. And I'm sure it must have been a memory of a lifetime. So
absolutely.
That's fantastic. From charismatic leaders to superheroes, as Dennis, as I say, I truly believe that every attorney who makes the time to be on this podcast is a superhero, and every superhero has an origin story. Can you please share for the audience yours?
Sure, I appreciate that. I think mine started when I was 11. Literally been working since I was 11 years old. At 11, I was mowing lawns for everyone in my neighborhood, and that evolved over time. One of my best friends, his brother would take a crew of us out every weekend to parades. So we were selling peanuts, popcorn, and Cracker Jacks at parades during the winter and snow cones during the summer. There aren't just 1 or 2 parades in the Los Angeles area. From the Mexican border up past Santa Barbara, there are 2, 3, 4 parades per weekend. So I learned to sell and get out there. But I think I learned the most I was lucky enough to land a job at 16 years old at an insurance company. And I was lucky to have a really, really good mentor. The president and CEO took me under his wings. He wanted me to learn insurance top to bottom. So I worked for him in administration, got to sit outside his office and listen to him do deals with politicians, with other insurance companies, other business people. Then he had me move to claims and underwriting and premium accounting and all the way through the insurance company to learn what each section did. So I really got to develop a good business mind listening to him and seeing how he ran the company. And he turned out to be a mentor who helped me with my law school entrance. He was one of my references. And, fast forward a few years, they became a client.
Amazing. Wow. So your exposure to the field that you wound up playing such a key role in started at the age of 16. That's so amazing. Can you maybe walk us through some of those steps? I think there's quite a few steps between 16 and having the privilege of opportunity of working with this leader in this space, through your college, through and then through law school and so on and so forth. So can you maybe walk us a little bit more through that?
Sure. I decided at a very young age, for better or for worse, as in 8th grade, I took a business litigation course, and I absolutely fell in love with it. So I decided in eighth grade, Dennis decided you're going to be an attorney. And I just stuck on that path. And so working through the insurance company, I actually got to work in their legal department. That was my first clerking job in law school. And so I was learning more and more about this area. And I really took to it. I enjoyed it. I understood the business side of it. And that's important. Being an attorney isn't just trying cases. There's also a whole business side to it. So I was being exposed to that as well as being exposed to the litigation.
That makes sense. So can you walk us through, maybe after you came out of law school, were you with another firm? How did you make the transition or decision to do whatever it is you did? And obviously you've had this firm for many, many years now.
Yeah, no, I clerked for a few firms, and then I clerked for the firm I ended up with. I was lucky. I had a choice between big law or the firm that I chose. And this may be a lesson for some younger attorneys. I had a chance to make a lot of money. I went for probably 60% less for a small insurance defense firm, but it met my personality, my goals, what I wanted to do. I wanted to be a trial lawyer. And I saw the ability to do that there. So I went to this firm, and we were there 6 years and kind of developed a firm within a firm. We had a lot of ideas of what we wanted from a law firm. And we were unhappy after a few years. We didn't like the direction of the firm. We didn't see partnership potential. We weren't sure we wanted to be partners with the people there. Good people, but not the same business sense. We had ideas for growth, for landing different lines of business. So a few of us became a firm within a firm. We shared similar backgrounds, similar ideas on how we wanted to treat people and technology and on and on and on. So we spent about 2 years talking about why we were unhappy and how we would do it differently, how we would do it better. And during that time, we wrote our Constitution. We talked about the pitfalls and how are we going to change this? We wanted a family feel with the firm. How are we going to do that? Easy. When we started with 16 of us, which was pretty big for a startup firm. But how are we going to do this when we're 40 attorneys and 80 and 100 and 150 and 200? That's a very difficult transition to keep those contacts and keep that family feel. I think we've done it. And our answer was the team approach. You create a family within the family. You have a team where you have the immediate contacts, immediate day-to-day contact. As the managing partner of the firm, we have 170, 180 attorneys. I can't touch everyone every day. I just don't have the capacity to do that. I care, but I can't do that. But the practice area leaders can do that.
That's incredible. So there's so many things to what you just said, Dennis, and I'll try to touch upon some of them. So one is that you mentioned that you created sort of the Constitution. You literally created the structure, the mental framework, the ethics, the values, all of that before you actually went out on your own. And so you knew exactly what you were doing when you were going out there, which is fantastic.
Well, we thought we did. We learned every day. We've learned something new. I know a lot more now than I did 30 some odd years ago, but we thought we did. And we had a lot of ideas. We had core values that we've never compromised. We had ideas for growth and who to surround ourselves with. And that's probably the key to our success is we're surrounded by really good people, good hard-hitting attorneys, really good trial lawyers, and great in their field, really good people you want to be around.
That's very cool. You mentioned something else, Dennis, which was that what you wanted to do or potentially big law was not a good fit for your personality and your goals, and that being a trial lawyer was more along the lines of that. And so can you maybe share what it takes to be a trial lawyer, frankly, of the caliber, and I can say this, that you are, in terms of personality, in terms of the goals you need to have, in terms of the mindset you need to have to excel at what you do?
Yeah, I don't think there's one formula. I think honesty and transparency are important. Juries are not dumb. Despite people talk about 12 dummies in a box, or I've never seen 12 dummies in a box. They get it. Windows open up into your personality during a trial. They figure out who the good guys are, the bad guys are. They typically, in my experience, get it right. The best trial attorneys are flexible. I've had trials. I remember one, I walked into the trial and we picked the jury. I'm like, oh my goodness, we have all business people and military. Like, I better play this straight. Whereas my opposing counsel was all over taking liberties and thinking, oh, you're losing them. You really are. But you need to understand. The other thing I think makes for the best trial attorneys, what I've learned from other folks that I've watched in trial, is the ability to fly at 35,000 feet. You need to be able to simplify. You need to be able to explain to a jury why you can win or should win. I've sat through closing arguments from opposing counsel and listened to them, and I'm watching the jury and they're lost. There's all this great evidence, but they don't know what to do with it. They don't know where to put that information. For me, it's about structure. It's about thinking like a juror. So I'll start with a special verdict form and say, question number 1 is X. You should answer it this way, and here's why. And now we'll talk about the evidence. We'll talk about the witnesses. We'll talk about why it should go that way. So you give them a structure of where to put this evidence. When you're dealing with 6 and 8 week trials, that's a lot to put together. So you need to be able to simplify. You need to be able to rise above and have a clear explanation, almost an elevator speech.
That's incredible. So I'm taking away transparency, structure, evidence-based arguments, and then clarity of thought and speech in terms of how you narrate your story. That's cool.
Transparency and honesty. I mean, jurors read you. They're trying to figure out who the good guys are or bad guys are. And windows open up into people during the course of a trial. They'll figure it out.
It makes sense. Taking a step back, Dennis. So obviously, insurance is a huge field, and going back to what you said, you had an early window into so many aspects of it. But right now, is it fair to say that you personally focus mostly on insurance fraud and affirmative litigation against insurance fraud? So, what specifically within the entire universe of insurance and the possible matters that are out there drew you to this specific niche?
It's a great question. Back in the late 80s, no one was doing anything about insurance fraud. One of our insurance company clients came to us, a few of us, and said, do you have an interest in fighting insurance fraud? What's that? What's that look like? We're like, well, no one's doing it. We'll train you. We're putting together the first units that deal with that. We like you guys. You're really aggressive litigators. You're hard hitting. I think you'd be a good fit. Clients asking, we'll do it, of course. By that time, I had tried a lot of different practice areas. I did construction defect, where I was representing geotechnical and soils engineers. Not for me. I did some police civil liability work. Interesting. Not what I want to do with my career. I'd done many, many other practice areas. And all of a sudden, I started doing that. I'm like, wow, that lights me up. So when we first started doing it, it was on the defense side. And it was easy. It was shooting ducks in a barrel because no one was looking. So the fraud was brazen. It was so easy to ferret out. So we were trying a lot of cases. A lot of our clients are like, no, we'll never accept a dismissal for waiver of costs. I actually answered ready for trial in a case. And the plaintiff's counsel said, Your Honor, I'll dismiss for a waiver of costs. And I said, nope, my client would not do it. So we ended up going to trial. A lot of the carriers thankfully took a hard stand against fraud. And then it led to an evolution where we went on the offensive. That changed in about 1995.
That actually is a great segue into my next question, which was, what was the moment that you realized that the best defense is a strong offense, and seems to be 1995? And then, how did you build a practice around actually playing offense and sort of taking the fight to the fraudsters, if you will?
It almost found me more than I found it. I was already developing a bit of a reputation as a hard-hitting litigator in fighting fraud. I was working with a certain insurance company, and they had a real suspect claim. I worked on it with them, and then a second and a third, and we went, wait a second. These are linked. And then we started working on it. It turned into a ring. It was a staged accident ring involving organized crime. We did really well. I got all the cases dismissed. They stopped paying after we got involved. but they had paid a lot of money before they involved me. And I got called to one of the vice president's office. Congratulations, great job, appreciate what you did. But boy, we spent a lot of money to get here. What can we do? I said, well, there's common law fraud, there's RICO. There's this new statute that was just passed. I played, this very, very small role in drafting it. No one's done it yet. You'd be the first. He goes, that's what I want. So I brought the first case under the statute and went very well, which led to the second, the third, and the 100th, and the 200th, and we're many hundreds in now with this really novel. California has an amazing novel anti-fraud law that's really a powerful tool to combat insurance fraud and hopefully drive fraud out of the premium dollars for all the public.
That makes sense. I wanted to ask you this, and this is again maybe a segue into the next question, which is, was this the $8.2 million verdict against defendant doctors? Was this that, or was that a separate matter? And if so, maybe we can talk about both and the highlights from both.
Sure, that came about 6 years later.
Okay.
Yeah, I mean, the next 6 years were quite a wild ride. You're dealing with a practice area with no case law. Everything's brand new. It's not like construction defect where you can open up a book and go, oh, okay, this is what you do next. We were on a new frontier. I mean, we were trying to rely on federal false claims cases or state false claims cases, but there's a material difference between those. So we were making policy arguments. There was no law to guide us. So, we developed kind of the template for how to put these cases together, working with insurance companies, securing the evidence before we ever brought a lawsuit, and then learning to litigate those. Those were heady and exciting times.
Can you take us maybe a little bit into that specific whistleblower law case? What was it like? How did it sort of come about? What was it like in the courtroom in terms of the dynamics, the jury, if it was involved, the window into the personalities? Just maybe synthesizing all of the things that we've discussed up to this.
Sure. The statute itself was very novel. It was patterned after the Federal False Claims Act. The Federal False Claims Act is actually the oldest fraud law in the United States. It's the Lincoln Law. It was brought to help the government root out fraud that was being committed during the Civil War. So someone could bring a lawsuit on their own, and the government could actually intervene in the lawsuit, but they're the victim as the government. So this was copied in California to help insurance companies. When it was passed in 1993, there's a huge work comp crisis in California. So this was designed to combat work comp fraud. And by 1995, it evolved to be work comp fraud or other areas of property and casualty losses. So this statute was passed with a recognition that law enforcement cannot go it alone. There's so much fraud out there. There's a recognition that there's not enough law enforcement to tackle all this fraud. So the statute was brought to bring the insurance companies to the fore, to help them combat fraud, give them a powerful tool to do that. And so we started using that. You sue in the name of the state of California, but the victim is the insurance company. And we started using this to go after organized crime, big fraud rings, medical practitioners that are doing really terrible things, and evolved into more fraud than I can tell you. After doing hundreds and hundreds of cases, every time I said, man, I think I've seen it all, something new comes up and I go, wow, never saw. People do the darndest thing for money. But and then the verdict you're talking about, there was an insurance company that caught on to these medical providers that were abusing what are called CPT codes. When you go to the doctor, there's little codes, for any exam you get or anything else. It's a language. They were abusing that, and they're billing for services not rendered. So we brought a lawsuit. We settled out 3 people before trial. 3 decided they wanted to give it a go. And so we went to trial, which is actually a funny trial. It was supposed to be a 13-week trial. We actually had some fun with the judge. The judge wanted to get to know us, and we all felt comfortable. So I played a little game with the judge and with opposing counsel. I have a lot of ties for whatever reason over the years.
You're not wearing one today.
Not today, but I have hundreds of ties. So I said, Your Honor, we're going to be together for 13 weeks. Trial ended up only going 8 weeks. I said, why don't we make a bet, all of us? No one will ever wear the same tie twice. And I did that knowing I had a lot of ties, and I knew they would look ridiculous by the end of the trial. And they did, including the judge. At one point, I had to turn to the judge. I go, Your Honor, you may want to zip that robe all the way up. He was wearing a bolo tie. Didn't look good. So anyway, we went to trial. It was the first of its kind type of trial. We couldn't go to the jury instruction books, Cashy or Badgie jury instructions. We had to write all of our jury instructions. we were all fighting about what the burden of proof was, something as simple as that, because we're suing under a penal code section. So is it beyond a reasonable doubt? Is it clear and convincing evidence? What's the standard? We were fighting on some very, very basic issues before the judge would even let us start the trial. And then going to trial, representing an insurance company, entities, especially insurance companies, aren't necessarily the most popular people in the world. So I had to get the jury to care about fraud, care about giving money to an insurance company, and care about those silly little CPT codes. And I remember as I introduced those CPT codes, and so these were first. This was the first trial under the statute. This was the first trial dealing with CPT codes. So a lot of firsts going on, a lot of unknowns. I remember the first time I mentioned CPT codes during jury voir dire, I got that furrowed brow by a lot of jurors, like, what is he talking about? I remember by the time my opening, started seeing the light bulb going on a little bit. I was kind of teaching a course on what it is and why it's important and why we should care. And then by the time my expert took the stand, I saw people nodding and caring, like, oh, thank goodness. The trial went for about 8 weeks, and we were very, very successful. I think the jury could give a maximum of about 8.4 million, and they gave 8.2 million.
That's amazing. What a win for your clients and for yourself. So kudos on that. It's interesting. You mentioned, so when you first started, there was no case law. So in a way, you just went out and created some. Basically, you created the case law. You created the precedents on which I assume future litigation rests in many ways.
We did. The statute is still, I won't say ill-defined, but not as developed as something like RICO or other areas. But yeah, we've had a lot of published opinions in this area.
Taking a step back from the actual practice that you've done, and you've represented obviously clients in hundreds of matters and so on and so forth, to the role that you play of managing the firm. You started many, many years ago. Your firm is maybe 3 decades, thereabouts.
Yeah, we're about to have our 32nd birthday. Yes.
Oh, excellent. Amazing. So what are some of the best practices that you have put in place, starting with that constitution that you mentioned, obviously, that has led to your 32-year run, and how do you balance what you do in terms of being in the courtroom with leading and managing a firm with 170, 180 attorneys?
Sure. I took over as managing partner a year and a half, almost 2 years ago. I was assistant managing partner for a number of years.
Congratulations.
Steve Manning was the managing partner, and he turned 70, and we thought this is a good time in our lives to switch places. So he's the assistant managing partner. I'm the managing partner now. We share a lot of similar philosophies. For me, I'm able to do what I do because of the people around me. It's not me. I'm the orchestra leader, but I've got really good people around me. I have a great CFO and COO and other people in key places that can run a lot of this. So I don't have to micromanage. I don't have to do all the little stuff. So I can make the bigger decisions. I can, again, fly at 35,000 feet and help guide the firm. That allows me, I still want to practice law. I still enjoy practicing law. I'm doing both the insurance fraud stuff and a lot of high exposure personal injury cases. I'm still trying cases. I have a trial in 2.5 weeks. So I'm able to do that by delegating, by surrounding myself with good people. It's a management style that fits my personality. And I think you get the best out of people. I think if you surround people, you empower them, you give them a chance to grow and make a difference, they really step up and they have job satisfaction and they do really well for the firm.
That's fantastic. So in addition to your personal legal practice and then managing the firm, you also serve as a mentor to, I believe it's dozens of law school students throughout the course of your career. So what role do you play, and how do you find the time, motivation, energy to play that role?
You can make time for anything you want to do. I love it. It's something, it's a form of giving back, but honestly, at the risk of sounding cliche, I get more out of it than they do. I really enjoy this. My law school has a mentor-mentee program for first years. I have a rule that once they get me, they're stuck with me for life. It's not a 1-year commitment. During the first year, I just help them with being a first year, giving them some insights and ideas. I have had some where I've had to talk off the roof. They're ready to quit. I had one of my favorite mentees who, before every final, he'd come to my office for a pep talk. So I let them define the role I play more than me defining it. I'm there. I make myself very available. I've had anywhere from 1 to 3 mentees every year for the last 20 some odd years. I have 40 some odd mentees now. It's fantastic. It's so much fun to watch them grow. As a first year, they come with open eyes, scared to death. What do I do? Am I going to survive? Oh my God. Second year, they got a little bit of a swagger. Third year, they know everything. And then all of a sudden they're a first year associate. And then they're like, oh my God, two partners gave me work. What do I do? They're back to being insecure, but it's fun to go through the growth. I mean, I've had some of them, actually most of them, I've helped them with their resumes. I was the hiring partner for our firm for 30 years. So I can help them with resumes. I've done so many mock interviews. I don't even know where to start. I help them go through that process so they know how to interview. I've had two that wanted to open their own firm. Well, I've opened a firm. I can help them with that. So I've been able to play a role, hopefully, in helping them along. But it's a great group. I try to get them together and bring them all together every year or two, which is really a lot of fun. I mean, a lot of them were 24, 23, 24-year-olds, single. Now they're married with kids. And it's really fun to watch them grow.
That's amazing. It sounds fulfilling, and I'm sure it's a great service to your school, to your law school, and to the legal community at large. A quick question on that. So, what fields of legal practice do your mentees wind up being in? Are they similar fields like yours, or are they kind of across the board? Or
they're across the board. It's so funny. I ask them when I first meet them, day one, what do you think you're going to do? And it never ends up that. They end up growing, but they don't know. They haven't been exposed. I've heard more people coming. Oh, I'm going to do employment law. They end up doing transactional something. They just go different directions. So yeah, they go all over the place. None of them have taken on insurance fraud yet, but I'm working on it.
Yeah, that sounds good. Switching gears a little bit, Dennis. So obviously, thinking about the role of technology in society, but specifically in your field, including AI, right? I mean, I would imagine that technology is a bit of a double-edged sword, right? And so how have you, in your experience, extensive experience, seen technologies make insurance fraud schemes more, sophisticated, raise the stakes, in terms of what needs to be, what the burden of proof is, etc. And then on the flip side, how are you using technology, again, including or not including AI, to sort of ferret out these schemes?
Oh, I love this question. This is such an important question in what I do. Since I've been fighting fraud since the 1980s, believe it or not, I mean, it has been an escalation in force. We got more sophisticated, they got more, and it keeps going and going. I've seen incredibly sophisticated money laundering operations where we've actually uncovered it, and I've helped show law enforcement how we uncovered it. And it's all technology based. Fast forward to today, we have AI. That is a game changer. The bad guys are using this to create fake invoices, fake videos, money laundering. I mean, it's being used in so many different ways. And on our side, insurance companies are using it to spot fraud. So it's such an arms race. And I don't know where this ends. The level of sophistication is crazy. The stuff we're uncovering, the stuff we're seeing, we're lucky in some ways to uncover it. It is really sophisticated. Turning to your second question, how are we using it? Oh my goodness, what a tool. At present time, I'm working on a fraud ring. It's about 800 or 900 staged accidents. The insurance company happened upon it. They had a feeling something was going on, and they were feeding us information. And I'm feeding it into AI. And as we're learning, we know how to, it's a game of prompts. You need to be able to prompt correctly or you're going to get garbage. So we're learning, prompting, taking depositions, prompting, getting more data, prompting. And we were able to break this ring. We can see links that I couldn't see before. It's a tool. I mean, I can't imagine how many man hours we would have had to put in if we could even break this. But using AI and being able to learn to prompt and ask the right questions, we uncovered an incredibly prolific nationwide fraud ring, which we will be prosecuting in the future.
Well, yeah, I remember, and actually you had mentioned the staged accidents, earlier in our conversation. I remember seeing on LinkedIn and some other social media sites of like somebody with a dash cam and, them being rear-ended, but looking a little bit, again, I'm no attorney, certainly nowhere near your skill level or experience level. And I was like, this seems a little interesting. And that was one of those apparently staged, so is that the kind of accidents that you're working on? Or
right now? Yeah. I mean, we did a lot of staged accidents in the mid 1990s. That was all the rage. And it kind of went away for a while. And boy, is it back. It's back with a vengeance. There's so much money in insurance fraud and these staged accidents and rideshare companies and other areas where they're taking advantage of it, and they are bringing a lot of suits. And it's not the cute, I need, chiropractic manipulation. Here's $3,000 in medical bills. Everyone's got a traumatic brain injury. Everyone needs epidural injections. Everyone needs a spinal cord stimulator. Everyone needs surgery. And all of a sudden you have $400, $500, $600,000 in medical bills on each case 800 and 900 times. The amounts of money are astonishing.
That's incredible. So clearly, as you mentioned, it's almost like a game of cat and mouse where they raise the stakes and you have to raise the stakes on your end, and we'll see where that ends. So on that note, within, obviously there's a lot of approaches, technologies, products, vendors out there. Two-part question. So one, how do you actually evaluate which of those are worth implementing in your practice, number one? And number two, what sort of, and this may be less relevant to your firm, just based on what you said, but what sort of misconceptions or apprehensions do attorneys generally have when adopting or evaluating, advanced technologies like AI?
Yeah, why don't we start with the second one first? There are a lot of misconceptions about AI. I think people are really afraid of it. They're afraid it's going to replace them. It's going to take away jobs. It's going to change things. It is changing things. It's changing things in my business. Insurance companies are now starting to mandate we use AI, and it's going to hurt certain business models. It's going to hurt the billable hour, but it's causing us to get a little bit smarter, learn about AI, learn where there's savings, and develop different pricing models. So it's causing an adaptation. You have to adapt, or you will be in trouble. I don't think it's replacing us as attorneys. I don't think AI can try a case. You never know. We'll see where this goes. But as of now, they can't try a case. But it can make our job a lot easier. It does impact billable hours. It's going to change us, but I don't think it's something, the genie's out of the bottle. So you can fear it, or you can embrace it and master it and do something with it. And that's the approach that I'm taking. In terms of which tools, both for AI and for everything else, I don't pretend to be an expert in any of these areas, but I'm surrounded by some really smart people who are. So we have a lot of conversations. I talk about my initial impressions, what I think of this type of technology, what we would want from it. We meet with some of the vendors and folks and see what they have to offer. We test drive different products. We see if we can refine it. And a lot of these can be refined. It's not just one size fits all. Here's our product, take it. It can be refined to what your needs are. So we work together kind of as a team to pick technology that works for us.
Looking ahead, and you've alluded to this a little bit in our conversation so far, Dennis, but what do you see as the next frontier in insurance fraud? So as technology evolves, as legal frameworks evolve, and you mentioned the statute, which is sort of not so fully baked yet, what new types of schemes are you expecting? Hopefully, they don't come to fruition, but what are you sort of seeing on the horizon at a high level?
I'm not sure I want to give a roadmap to bad guys.
Absolutely not. No. Certainly not.
I'm kidding. I think the future is international. We are seeing more and more fraud. We think of this as more local or, kind of in our jurisdiction. What I'm seeing now more and more is global. We're seeing stolen cars going from here to Africa. We're seeing money laundering. We're seeing third-party litigation financing playing a role. We're seeing links that are more and more international. I have a case involving organized crime a few years ago, and we were able to trace the money laundering from Los Angeles to San Francisco to New York, and New York to Russia. So you can see the flow of money. You can see the fraud. There's too much money here. So people are going to take advantage, and they're getting much more organized and using AI and learning more about insurance companies and how to pass off false claims. So these are no longer local jurisdictional issues. These are becoming national issues. I just got back from the Global Insurance Fraud Summit where I taught, and I had some amazing conversations of folks from all over the world talking about the fraud they're seeing. And we're all shaking our head going, oh my God, we have that here too. Oh, I wonder if these are linked. And it looks like they are. So this is a larger global problem where people have tapped into ways to make easy money.
That's amazing. So it almost ties back to what you shared at the beginning of the conversation, where earlier in your career, you came across an insurance company that said, hey, I think these accidents in maybe this region or the state were linked. And now you're seeing that same pattern play out at a global scale, which is fascinating.
Yeah, the numbers, the amount of money at stake is huge. I mean, you're seeing third-party litigation funding or third-party litigation financing becoming a bigger and bigger player in general. And there's some great ones and some that are not so ethical or great, and is causing the numbers to go up. We're seeing the damage models being much, much, much larger than they used to be. So where we were talking about thousands, now we're talking about hundreds of thousands and millions of dollars each claim.
Well, this has been a great conversation, Dennis. Just a couple of quick questions to wrap us up. So, you're a member of the American Board of Trial Advocates, which obviously signifies extensive trial experience and expertise. What advice would you give to a young litigator today, including the dozens that you've already mentored, who wants to become like a true first chair trial lawyer and not just a discovery litigator?
I think even broader. Think about your career path. Ask yourself every year. Am I happy where I'm at? Am I really staying true to who I want to be, where I want to go? If you want to be a trial lawyer, are you working at the right place to learn the skills? Do you have a good mentor? Do you have a path in to lead, to do trials? I have a couple good young attorneys that are working with me now, and they've made clear they want to try cases. So I have a trial with one of them in 2.5 weeks. It's such a great learning experience. She will do phenomenally well. And learn this craft. It's a dying craft. It's a dying breed. We're seeing less and less people getting trial experience. And we need to train the next generation. What happens when we're gone? Who's going to try all the cases? I am seeing insurance companies running out of good trial attorneys. I get calls a couple times a week saying, hey, we have the Bet Your Farm case. Will you try this for me? Like, there's only so many trials I can do. And there's only so many of my cohorts who could do all these trials. So we are really spending a lot of time in our firm trying to train up that next generation of trial attorneys. It's really important, and it's very fulfilling. It's really a great thing to be able to get into a courtroom, fight hard. As I tell my attorneys, there's no shame in punching your opponent in the nose, just never stab them in the back. It just hit them straight on. We all fight hard. I've done this in trial where we fought really hard, but we've had a beer afterwards and celebrated together, whoever wins. It's not personal. It's growth. It's learning to be a better and better attorney, be ethical, be honest. I've had the pleasure of trying cases against other ABOTA members. I learn so much every time I'm in trial with them, but they do it right. It's honest. It's ethical. You don't have slimy things happening. And that's the way this should be. That's the way this profession was meant to be. Let the jury decide based on the facts and the evidence, not on sharp litigation tactics.
Certainly words to live by, Dennis. You mentioned there's a shortage of trial attorneys right now, and so for lawyers and insurance professionals who want to get smarter on identifying and combating fraud, what are some high level resources that you would recommend that they look at?
There are a lot of great organizations that they can join, from the International Association of Special Investigation Units. It's a global insurance fraud organization, the Global Insurance Fraud Summit, Southern California Fraud Investigator Association, Anti-Fraud Alliance up in Northern California. There are tons of organizations who have great speakers come in, teach about it. You start to learn, and it really is a community. It's a community of people with the common focus of fighting fraud. So there's a lot of education, a lot of ability. If you're an attorney and you want to do this, join a firm that does that. Get involved in that, and you can have mentors who can teach you and bring you along. There's a whole learning curve to learn about the various forms of fraud that is out there and how to spot it, how to combat it, what to do, whether it's on an individual claim or bringing them together in an affirmative action.
Amazing. Final question for you, Dennis. Is there a question that I should have asked you, but I didn't?
How about my family?
Yes, please. I'd love to learn more about your family.
I mean, I juggle a lot, but I'm lucky to have an amazing wife. We've been married 37 years and 3 amazing kids, and now 1 grandson.
Fantastic.
So they're my pride and joy, and never skimped on any of that time. As they were growing up, I did all the coaching and all that good stuff. So they're my pride and joy, and kind of what makes me tick.
Amazing. Well, on that wholesome note, Dennis, it's been truly a pleasure speaking with you. Thank you so much for sharing your time, your insights. I certainly found it extremely valuable, and I have no doubt that our audience will as well. So thank you very much.
Appreciate it. Thank you.
The Litigator's Edge podcast requires more than a conversation. It takes action, research, and collective wisdom. If today's episode resonated with you, we'd love to hear your insights. Join the conversation and help us shape the future together. We'll be back with more stories, strategies, and real-world solutions that are making a difference for everyone. In the meantime, be sure to subscribe, rate, write a review, and share it with someone you think would benefit from it too. Thanks for listening, and we'll see you on the next episode.